got a special treat for you. We are so excited to have you to take a part in our informative and knowledgeable event. Let me tell you a little bit about who we are. We are Women's Entrepreneurship Network United Incorporated is made up of dynamic group of distinguished businesswomen locally and nationally with the central location being in Atlanta, Georgia. We was founded in 2019. The members are dedicated to helping, elevating, and networking with women entrepreneurs to expand their reach of female-owned businesses locally, regionally, and nationally by eliminating gender, economic barriers used to undetermine their competitive potential, thereby maximizing their connections to the consumer market. Our mission is to educate the growth of female entrepreneurs by providing the business resources, mentorship, and networking opportunities needed to achieve success. We Knew also serves the community. Our current membership has been instrumental in reaching over 1,000 women, men, youth, and families in the need of food, clothing, and mentorship. Our collaborative partnerships include Dress for Success, Sadie G. Mays Health and Rehabilitation Center, Cool Girls, DeKalb, and Fulton County School Systems, Delta Sigma Theta Sorority Incorporated local Metro Atlanta chapters, and local medical health experts in support in mental and physical health education. So that's a little bit of telling you who we are. I am Devera Williams. I'm one of the co-founders of We Knew, and other co-founder is Letty Hill also. So before we get started, we do have a sponsor, and her name is Tamara Lewis. And let me tell you a little bit about Tamara. We call her Tammy. She's a regional vice president of Prime America, founder of Pink Pearl Hero, and creator of One Dope Planner. She transitioned from a 12-year pharmaceutical career to finance and entrepreneurship, focusing on wealth management. After a breast cancer diagnosis in 2018, Tammy founded Pink Pearl Hero to advocate for women's self-care. Due to extensive surgeries and reconstruction from breast cancer and inability to carry anything over 12 pounds, divine timing and her love for technology kicked in. She created a digital planner, One Dope Planner, a digital organization planning experience where paper meet digital. The One Dope Planner enhances productivity, is portable, customized, and eco-friendly. Tammy has also loved for community service, and she is also a member of Delta Sigma Theta Sorority, and gives 17 years of service to Girl Scouts of America. So no further ado, we're going to introduce you to our sponsor for tonight, Tammy Lewis. And I think she is on here. I see her. Tammy, I think you're on mute. There you are.
I am. Hey, ladies. I apologize for not being on the screen. I'll be on the screen in like here in a second. But yes, it's a pleasure to be around other like-minded women. I'm so excited for the call tonight. I love everything about finance, and I love everything about tech and productivity. So tonight, I am going to I guess there's going to be a raffle for the One Dope Planner. It is a digital planner where paper meets digital. And so I will make sure that in the chat, I'll put the information for our social media so you can see the planner in action. But the digital planner came in play, just like my soror said, because I couldn't carry anything over 12 pounds when I was going through all of my surgeries due to my breast cancer journey. And so again, it's all about making turning lemons into lemonade. And I just turned it into a digital product. So, but it is definitely built for you to be more productive and not busy. So just imagine having a 12-week planner. and five subject notebooks all in one in a digital planner system. It also synchronizes to my phone. So anything that I do in the planner, so you will need a tablet or some type of tablet, Android or iOS to use it, but it goes with me everywhere I go. So I never lose it because everything is stored and backed up in the cloud. So I'm excited tonight. I'm excited for the three women. I think we got three, right? So the three women that will raffling off to get this, and I'm
Or
excited
men,
to or
or
men
men.
or men. Okay, I don't have my glasses on. Or men that will get this. You will get a one-on-one 1 hour session with me. And if you don't even have a planner, I'm big on time management and time managed strategies. And so we'll be going over that so we can get 2025 off with a bang. We're 7 weeks from right now, we'll be saying Happy New Year. And one of the biggest things that I see when I sit down with people in business and also in productivity is their time management, is managing their time so their time does not manage them. So I'm totally, totally excited about that. In the bundle, I forgot to disclose this part. In the bundle, you will get the planner. You will also get the dope budget insert. You will also get the dope devotional insert, and you will get the goal setting planner. So all of those, that whole package with my time is right around $300 in value. But I'm excited for the three people that will be able to get that. So thank you. And I'm excited about hearing about the great information tonight.
Thank you so much, Tammy. We appreciate that. I know the winner's going to be excited, whoever they may be tonight. And we will have a raffle right after we hear from our speaker. So now let's get to our speaker. I'm so excited. Shannon Wilson. Shannon Wilson, Esquire, started her legal career with State of Tennessee, where she investigated employment and housing discrimination claims with Tennessee Human Rights Commission. She then transitioned her state practice to the United States federal government, where she serves as an attorney and representation specialist for Federal Labor Relations Authority. She was dedicated to helping families and communities thrive through maintaining fair work environments, fair housing, and fair collective bargaining. After leaving the federal sector, Shannon served as a contract attorney for several large law firms and legal placement agencies. Yearning to get back to her passion of service, her career path took a twist. Her focus shifted from building legacies and serving through fair work environments to creating legacies through estate planning. At that time, she became the lead attorney for the Atlanta office of a boutique estate planning firm. While there, she developed a passion for empowering individuals and groups to create and protect wealth. Shannon took that passion and commitment, propelled it forward, and is now the founding attorney of Legacy Legal LLC. Shannon is dedicated to and passionate about helping individuals, communities, and mindsets thrive. Her estate planning practice is compassionate, empathetic, thorough, and educational. In addition, she is a VA accredited attorney and often works with veterans on enhanced estate plans that are specific to their families and their benefits of their service. Shannon encourages her clients' educational workshop audience and the communities that they each represent to understand one of her mottos. If you neglect to plan, you plan to neglect. Like that. Shannon is honored every time she helps create an estate plan, building legacy one family at a time. So, no further ado, Shannon, we are so excited to welcome you to We Knew.
Thank you. Thank you. Thank you so much. And thank you for having me here this evening. I'm really excited about this because one of my sweet spots and joys in life is presenting to groups, especially groups like this. So um, this is going to be educational by nature. And at the end, if any questions that you all have, feel free to ask. So what I'm going to be talking about tonight is basics of estate planning. And this is for anyone. And when I say anyone, I mean anyone over the age of 18 should have an estate plan in place. And that looks very similar in some respects, but the primary part of it is that every estate plan should answer at least 3 questions. One, what happens if I become incapacitated? That's the first question that every estate plan should cover. The second is, what happens when I die? That's the part that most people are more familiar with and we hear about most often. But more importantly, and where my passion lies, is what do I want my legacy to look like? All right. Everyone on here probably has in their minds an image of what you want your legacy to look like. But everyone on here also has 500, 1,000 pieces to their life's puzzle that you probably don't know how to put together to make sure that image comes to fruition. So that is what I do all day, every day. I love, love, love what I do. Work never feels like a job to me. I often say, if it ever starts to feel like work, I'm either doing something wrong or it's time for me to retire. And I'm doing neither right now. So I continue to love what I do. With that in mind, a colleague of mine once said that a proper estate plan includes both lifetime and at death planning components to account for the possibility of incapacity as well as the certainty of death. Possibility wise, let's talk about a few statistics. 30% of people will become in some way incapacitated during their lifetime. And that number is increasing daily. So, what happens if you become incapacitated? Another statistic that you all probably know innately, but you haven't thought about it, is 100% of us are going to die. We just do not know the day nor the hour. So, what does that look like, and how do we function through that? The main part of it is estate planning has to involve creating your legacy. And like I said, everyone's legacy looks different. But how do we do that? We have to plan, right? I don't know if there's anyone on here that plays chess, but I know that chess is a game of strategy. Much like chess, estate planning is a game of strategy. So, legacy creation, estate planning, it requires strategic planning and being a strategic thinker. So, how do we do that? And how do we succeed in doing that? And how do we succeed in planning and then protecting your estate? And by the way, your estate is anything connected to you and your name when you pass away, right? I often hear people say, well, I don't really have an estate. Everyone that has life and breath and even two pennies to rub together has an estate. So, what does that look like? How do we succeed? There's 3 steps. The first is you have to know the rules, right? I don't know if there's anybody on here that's played a game and you did not know the rules, but I know one thing for sure. If you don't know the rules, you're not going to win. So that's the first step in estate planning is you have to know the rules. And I'm going to talk about those rules and who makes the rules. The second part is you have to know your predators. We all have different layers and levels of predators in our lives. So I'm going to go through who those may be, what those may be, and what it looks like when it comes to planning your estate. And the third step to success is you have to know your options. We live in a world full of options. You know, we can't even go to a restaurant without a menu that's like a book, right? But in estate planning, we really only have 2 options, and I'm going to tell y'all what those are. So let's talk about number 1 and knowing the rules. And I love to start with this story with my sweet, sweet niece who is now 12. When she was 3, she was visiting, we were playing Uno, right? Everybody, I'm sure everyone on here can relate to Uno. However, she had beat me at least 8 times. And I'm thinking, why does this 3-year-old keep beating me at Uno? So I said, okay, we're going to take a snack, go take a snack and we'll come back and play some more later. So while she was eating on her goldfish, I sat down and I examined the Uno cards. Come to find out, she had torn a slight little corner, like a tear in the corner of all the draw 2s and all the draw 4s. So when I figured that out and she came back after her snack, you know, her goldfish and her juice box, she came back and she says, oh, Tia, can we play again? Yes, we can play again. Well, the next few games I won. And she was in tears because I was winning. And she got, at the age of 3, a very interesting lesson on rules and cheating. So she knew the rules. She was playing the game by a different set of rules than I was. So you have to know the rules. So let's talk about the rules in estate planning. The government makes the rules, much like my niece was making the rules in that Uno game. The government makes the rules for estate planning. And there's three scenarios that the government makes the rules on. The first is who can speak for you when it comes to finances and legal issues. The government's rules say nobody can speak for you when it comes to finances and legal issues unless you authorize that person to do so. How do we authorize someone to speak for us financially and legally? It is through the legal document called a power of attorney. So that's the first document everyone should have in their estate plan is a power of attorney. This is the document where you outline and you name a person and a backup to speak for you if you're unable to speak for yourself when it comes to finances and legal issues. All right. Who should this be? It should be someone that you trust with a blank check or that you trust with the debit card and the PIN because you're giving them access to all things financial for you. And you are also putting that in place for them to use in the event of it being necessary. Now, the power of attorney is only effective while you are living. It stops having authority once you pass away. The second important part about power of attorney is it has to be given. You cannot get power of attorney, right? At least once a week, somebody calls and says, I need to get power of attorney for my mom or for my dad. And I always explain to them, you can't get it. They have to give it to you. So how do they give it? Via that document called a power of attorney. All right. The government also makes rules for who can speak for you when it comes to your health care. All right. And those rules say there is nobody that can speak for you with regard to your health care unless you have authorized that person to speak for you. How does that authorization take place? Again, it takes place in a legal document that I call a healthcare record. And that healthcare record usually has 3 parts, but I use 4 for mine, and I'll tell y'all why when I get to the 4th part. So the first part of that document, that healthcare record, is where you name a healthcare proxy. Some people call it your healthcare agent. This is the person, and a person and a backup, that will speak for you with regard to your healthcare and any medical issues if you are unable to speak for yourself, right? You have to be unable to speak for yourself. Why? Because if you can speak for yourself, especially medically, you will. So again, this is the document that allows you to outline who will speak for you with regard to your healthcare if you're unable to speak for yourself. That person is called your healthcare agent. I always encourage my clients, make sure it is somebody that can separate emotion from decision. Make sure it is somebody that is not too sensitive, right? I'll use my personal self as an example. I have 2 sons. They are excellent decision makers in all things, but one of them is way more sensitive than the other. He will never, ever be named as my healthcare agent or proxy because my documents say I want to do not resuscitate after 2 weeks. If they have to look to him, he'll be the one in the corner saying, I know that she wants that, but I can't do it. I'll never name him. All right. The other one, on the other hand, he has this uncanny ability to separate emotion from decision. I don't think he loves me any less, but right. If they have to ask him, he'll be the one saying, this is what she wants. She wants it after 2 weeks. It's been a week, 6 days, and 22 hours. Are we ready? Right. So you know your people. People often ask me, well, who should I name, Shannon? I can't tell you. You know your people. I can offer suggestions and pull some of those things out of you, but you know your people. You know the people that are in your circle of influence and the people that you trust. So the first part of the healthcare record is where you name a person called your healthcare agent. The second part of the healthcare record is what we call an advance directive. In some states, they call it a living will, right? In some states, they also call it a healthcare power, right? And so what this is the part of your healthcare document where you give that healthcare proxy or agent that you just named, as well as the medical professionals instructions. This is the part of the document where you say things like, I want to do not resuscitate, or no matter what, please don't feed me or hydrate me via tube or IV. Or I recently had a client who said, I have very, very small veins. If a needle becomes necessary, I would like pediatric needles used. So all sorts of things like that, all sorts of information goes into that document so that the healthcare agent and the medical professionals are not flying blind. You're giving them a guide as to how you would speak for yourself if you could. The third part of the healthcare record is what I call an enhanced or extended HIPAA waiver. And I'm sure everyone on here has been to the doctor in the last 20 years. And when you check in, you check the box saying you got their HIPAA policies. Most people don't even read them. They just check the box so that they can be seen by the physician. What you're checking is saying, yes, doctor, RN, office manager, you may leave a voicemail at the number I have listed here, or you may leave an email address, I don't care who reads it, that I leave for you. But in the estate planning arena, this is where we list additional people that can have access to your information. They might not be speaking for you, but they can have access to your information. So for instance, my sensitive son is on my HIPAA waiver because I know that although I don't want him speaking for me, if something happened, he would probably be the first person calling to try to figure out what was going on. And so, or standing right there by me. So the HIPAA waiver is where we list additional people. This is also where sometimes people list a primary care physician or a specialist of some sort. Or I had one client who has 7 siblings, and she said, we all talk every day. Yeah, all 8 of them talk to each other at some point during every single day. She said, may I list all of them? I said, sure, you can list all of them. Her husband said, oh, great. Thank you. Because if something happens to her, my focus and attention is going to be on her, not answering the phone calls from my in-laws all day long. So that's the third part of the healthcare record. The fourth part, and this is something I do especially for my clients, I only know of one other estate planning attorney in the nation that includes this, and I used to work with her. But this is what I call your end of life or transition instructions. I'm sure everyone on here has seen, heard, or personally experienced families that fall apart and are in forever disagreement from there on over what somebody did or wanted at a funeral, right? I've experienced it both personally and professionally. So that's why I include this document, because in this part of the healthcare record, I allow my clients to outline things like, I want to be buried, or I want to be cremated, or I want a faith-based service at the First Baptist Church, or I want my sorority to do their ceremony at the family hour instead of at the funeral. Or no matter what, please don't let my cousin so-and-so speak at the services. Or I want to be cremated and my ashes spread in the Pacific Ocean. Or I don't want a funeral. This was one of my favorites. I don't want a funeral. I want brunch, because this particular client had brunched with a group of ladies every Saturday for years. So she said, I don't care what day of the week it is when I die, whatever the next Saturday is, I want my funeral held at 10 o'clock, followed by brunch at this location. She's like, we don't want to go back to the church for repast and all that. This is what I want. So this is the part of the document where you are allowed to outline those things. Some people take it and get very specific with it. Others say, I'm not going to be here. But again, it is your opportunity to reiterate things like, do you want to be buried? Do you want to be cremated? Also, sometimes we put in here what your wishes would be with regard to organ donation or organ donation for research or transplant purposes. All right. So again, the first document everyone needs is a power of attorney. That's for finances and legal issues. The second document that everyone needs is a healthcare record that outlines your healthcare. Both of those documents, the government makes the rules for while you're living and says you're the only one that can speak unless you have one of these documents in place that says someone else can speak for you. The third document that everyone should have in place in their estate plan from the time they turn 18 is a last will and testament, or a will. This is the document that allows you to plan strategically for the inevitable of death. All right. This document is a public document, It is filed with the probate court. And once it gets to the probate court, and most of what I'm saying is general, and it applies across all states. All right. So once it gets to the probate court, now it is a matter of public record. And every state does not call it probate. There are some that call it different things. So once it gets there, it becomes a matter of public record. And anyone can get a copy of it, right? Nosy neighbors, family members you haven't spoken to in 40 years, coworkers that want to know what you have, Visa, MasterCard, American Express, anyone or any entity that thinks you owe them or they want to see what you have, they can get a copy of it. All right. Most people like to live their lives in a private way while they're living. And they want that to transition with them into their passing. So the will, again, is the public document that the state is looking for when a person dies. If a person dies without a will, the word is they die intestate. And now the state and all of those creditor, I call them creditor predators, they get to decide what happens with all of your stuff, right? I don't know about you all, but I work very hard and I don't want the state or some other entity stepping in and saying the things that I'm leaving for my loved ones go to another entity. So is there a way to create the rules, have your estate planned strategically, satisfy the requirement of a will that the state is going to be looking for, yet also use your rules and do so in a private manner? Yes, and that is through a trust. I'm sure everyone on here is hold of a trust. It's becoming a buzzword, right? And so what goes into a trust? A trust is also for planning for death, although it also has living components to it. When you have a will and a trust, now your will changes formats and it becomes what we call a pour over will. So rather than the shoes, the clothes, the handbags, the firearms, the furniture, the family heirlooms, the Greek paraphernalia, the dog, the piano, rather than all that stuff being listed in the will for the whole world to see because the probate court has it, now your will simply says, I leave everything in my trust. That way you don't die without a will, leaving you open and susceptible to creditor predators and probate. But the trust itself is private and nobody sees the trust. You manage all of your assets just like you do now. You continue to manage things and you can move things in and out of certain types of trust. There's different varieties of trust. You can move things in and out of them. You can sell them freely in some types of trust. A lot of times people create charitable foundations or charitable organizations within a trust. We also, for business owners, we include business succession planning in the trust. And so now what you spend or expend on your trust and your estate plan is a business expense. All right. So again, everyone needs the power of attorney, the healthcare document, and the will. But there are only 4 categories of people I recommend a trust for. The first category of people I just mentioned are business owners. I always recommend a trust for business owners so that they can protect and transfer that business properly upon passing or if they become incapacitated. The second category of people I always recommend a trust for are those who own real property, whether there's a mortgage on it or not. Real property is houses, land, and timeshares, right? You all may not be surprised, but there's so many people out there that have timeshares and they don't realize that that is considered real property. So that's the second category of people I always recommend a trust for. The third category of people I always recommend a trust for are those who have assets that can more strategically be transferred without the need for probate. So that's people with bank accounts and life insurance policies and all that stuff we talked about, and vehicles and houses and cash, right? Cash in the backyard or in the piano bench or wherever you have it stashed, or and stuff, right? So those are the people who I always recommend a trust for. And then the fourth category of people I recommend a trust for, it's got 3 parts to it. One is anyone with minor children. Having minor children brings with it a whole other level of planning, especially when it comes to what would happen if there's still minors upon your passing. So I always recommend a trust for individuals or couples that have minor children. I also recommend a trust for anyone that is in a blended family. And let's face it, blended families are more traditional these days than a traditional family. And that comes with it the whole yours, mine, and ours complex. So that complicates, in some instances, what an estate plan can and should look like. And then the third part of the fourth category is, quite frankly, anyone with an interest in leaving a legacy, right? I love to say when you neglect to plan, you plan to neglect. So having that legacy in place allows you to live through your life without having to worry about if something happens to you. It also allows you to live into death without your loved ones that you leave behind not being able to grieve because they're worried about the business aspect of your passing. So the first step to success in planning your estate is you have to know the rules. The second step is you have to know your predators. And we all have different predators. So the first predator is the government. Why is the government a predator when it comes to your estate plan? Because anything attached to you is part of your estate when you pass away. Monetary assets specifically. Many states have state estate taxes, meaning you pay taxes based on the value of your estate when you pass away. Some states, that tax is more than 20%, right? Many states also have state inheritance taxes where if you inherit something from someone, you have to pay taxes on the value of it. I'm here in Georgia. We have neither, which is good for those of you that are here in Georgia, but know too that many other states do have that government taxation. Also, there are federal estate taxes. Currently, the number is circulating right around $11.8 million. So anyone with about that has to pay federal estate taxes. So the government is automatically a predator, not to mention the fact that every time you go to court, probate court or anything else, it costs. Here in Atlanta, it costs to even go park at probate court. And so there's costs associated with everything. The second predator is long-term care. I'm sure all of you have heard or maybe even personally experienced or been this person that said, oh, when I get older, I just want to age in my home. I want somebody to come into my home and care for me. I don't ever want to be in a facility or anything like that. It sounds fantastic, but somebody has to pay for that. So long-term care costs become predators because the average cost of having someone come into your home and care for you 24 hours a day is hovering right around $22 an hour. If we did the math, that ends up being more than most people make in a year. So if you're sitting at home and you need around-the-clock care, you're probably not working. So where's that money going to come from? So long-term care costs, again, become predators. Business partners are also predators. I see the questions popping in. We're going to do a Q&A at the end, so I'll address all of those then. Business partners. Business partners become predators, and they are predators because it's all in how you organize that business in the first place. If you're calling your business a partnership and your partner thinks it's a hobby and something happens to that partner, everything could be up in the air, right? I'll use myself as an example. If I went into business with somebody on here and then I later die and say our business is highly successful and profitable. Well, you probably think, great, now I get the business. But my family thinks, oh, great, now we get her part of the business. So again, it's all in how that business is organized, and business partners, the partners is in quotes because it's all in how you set up that business and it can make or break an estate. Family, that's probably the hidden predator that circulates around all of us, right? Every family looks slightly different. And family is usually the one that tugs at our heartstrings the most, but they are also the ones that get on our last nerves the most, right? Especially when we're talking about estate planning. Why? because sometimes we have family that says, oh, I have 4 children. I want to treat all of them equally when I pass away. But one of those 4 children has been getting their part of the inheritance their whole life. And they know that. And well as everyone else around them, all of the siblings know, right? So sometimes it might not be the best idea to treat everyone equally. Also, sometimes those children don't ever leave home, right? Our goal is to get them to, 18 or 21 or out of college or whatever your individual family goal is. Right? But sometimes things happen and they come back. Maybe somebody gets divorced. Maybe a spouse dies. Maybe they just never leave. Maybe they don't have the motivation. Whatever the case may be, family can become predators, right? Not to mention the fact that blended families carry with it a whole other level of uh, predatory behavior. So family can become a predator. Then lawsuits. Nobody likes to get sued. I'm an attorney. I don't like getting sued. I don't even like being in the courtroom. All right. I'm good at it, but I don't enjoy it. And I'm at a space and place in life where I don't do anything that I don't enjoy. So lawsuits can make or break an estate. And I'm going to give you all an example that hit home because I was involved in this case. So I co-partnered with a colleague of mine in Florida, and her client was a physician. More specifically, he was a neurosurgeon. And he had allowed Google to be his guide in his estate planning. And so one evening, this man was in his early 80s and still working. So one evening, after a very long shift and very long surgery, he's on his way home and he fell asleep. He had caused an accident. In that accident, a young mother and her 2 children under the age of 5 passed away. So since he had allowed Google to be his guide in his estate planning, he thought he had everything in line. He also had some financial things that were tied up in this Google guided estate planning because he had a trust, but it wasn't properly funded. And funding is the process that you have to go through once that piece of paper, that trust is in place. You have to go through the process of making sure everything is properly covered. He neglected to do that because, again, he allowed Google to be his guide. Shortly after that accident, the family of that young mother sued him. So while he thought he had created a nest egg for his children and his children's children, right? That was all taken by this other family. They sued him and they won. So he lost everything. So again, lawsuits can become predators right before your eyes. So remember the steps to success. You got to know the rules. You got to know your predators. The third step to success is know your options. All right. You get to decide who gets to control everything, right? A lot of people are control freaks and they want to control everything. I'm sure y'all have heard of people talking about controlling from the grave, right? Estate planning is your opportunity to do that. If you realize that you're one of those people, be strategic about it, right? So you get to say who controls. You get to say who benefits, right? Do you want everything going to your nephew? Do you want everything going to all of your sorority sisters? Do you want everything going to your children? Do you want to skip over your children and leave everything for grandchildren? Do you want everything to go to your spouse if they outlive you? What do you want? You get to say who benefits, right? Who gets those pearls? Who gets the shoes and the handbag collection and grandma's china? Where does that go? And then you also get to say, when does that happen? Do you want to see those things and those people benefit while you're still alive and well so that you can see them enjoy it? Do you want to have everything set up for if you become incapacitated, especially for business owners? Is the business going to crash and burn because you're in a coma at the hospital? Right? Or do you want to wait until you pass away and not have to be worried about it? And what about planning for spouses and incapacity with that end and children and disabilities? So your options, you get to say. So really, there are two options when it comes to estate planning. You can use the government's rules, which says we get to say who controls and how and when and what all that looks like, or you can use your own rules. All right. Remember, I said when you neglect to plan, you plan to neglect. Let's talk about some celebrity types who neglected to plan because they use the government's rules, right? And there's many of them. We're about to go through them. Some of these you might find shocking. All right, so the first one, Chadwick Boseman, Black Panther. He chose to use the government's rules because when he passed away after filming the last Black Panther and a long bout with cancer, he didn't have a will in place. All right. The downfall to that is twofold. One, he was in California where those estate taxes we talked about are 20% and higher, right? Two, he was a newlywed. And the laws of intestacy, which is what happens when a person dies without a will, every state has basically a chart that says, well, who gets it when you die without a will? So typically, the laws of intestacy say, was this person married? If they were married, then it goes to spouse usually. Did they have children? If they're married with children, generally in most states, the spouse and the children share. Some states say it's, half to the spouse, half to the children, no matter how many. Some states say it's a third to the spouse and the rest goes to the children. So it varies from state to state. Right? So he was married. However, like I said, he was a newlywed. In this situation, fortunately, his parents, which would have been the next in line if he didn't have children, or which he did not, his parents said, you know what, we like you, we love you. Yes, you are entitled to part of his estate. But that could have gone way south in the other direction. All right. When you neglect to plan, you plan to neglect. Abraham Lincoln, he was the president of the United States. When he was assassinated, his estate was valued at about $18,000. That's not much in today's times, but at the time, he was considered extremely wealthy. He didn't have a will. So now every estate planning case, every probate case, they all go back and reference this was the first person basically that died without a will that it was relevant to. Kobe Bryant. Kobe is my example of somebody who planned and planned perfectly, right? I know he's on this slide that says when you neglect to plan, you plan to neglect, but I put him on here because he planned perfectly. He and his wife, Vanessa, had an estate plan in place. It had the power of attorney, it had the healthcare document, it had the will, and it had a trust. When they put that plan in place, they actually agreed they would never be on the same aircraft together. When they put that plan in place, their youngest daughter was not yet born. So this is why after Kobe passed away, Vanessa was able to go to the court, say to the court, may I amend our trust to now name specifically our youngest daughter. She didn't want her growing up with the stigma of being future unborn child, right? So the court said, yes, you may. That's also how she has been able to carry forward with many of his contracts because they put the businesses, all of those contracts were under different businesses. They put all of those in the trust and did business succession planning that said, if I die, most of the businesses were Kobe's, but if I die, my wife Vanessa can continue to carry forward. That's how it was able to work. He's my example of planning perfectly. Aretha Franklin. Before Aretha's 12-hour funeral was over, the state of Detroit already had probate action. Why? Because state taxes there were about 22.5% at the time of her passing. All right. Some of you may remember in Aretha's later years, she would show up at concerts and she wouldn't get paid. So she would say, I'm not going on stage. She would refuse. She did that here in Atlanta several times. So she did not have an estate plan in place, is what they thought originally. And the interesting thing about this is Aretha has adult sons that have special needs and are going to need to be cared for the rest of their lives. So I personally, not professionally, but personally, I believe somebody did advise her and she just chose not to do it. But I digress. Originally, they thought Aretha had no will. About a year after somebody had been named administrator for her estate, they found three, one, two, three handwritten wills. Yes, a handwritten will is valid in some states. Okay, Michigan being one. However, in those same states, if the will is handwritten, it still has to satisfy certain criteria. So for instance, here in Georgia, even if it is handwritten, it still has to have witnesses and it should probably be notarized, right? And the witnesses and the testator, which is the person that puts it in place, should sign at the same time. So what they had to do was they had to halt everything that was going on with her estate. They had to verify the authenticity of those handwritten wills because although they did not contradict one another, they didn't all say the same thing. So now they had to go back and figure all of that out. When you neglect to plan, you plan to neglect. Michael Jackson, the king of pop. When Michael Jackson died in 2009, he had just made a very large purchase. So again, he died in 2009. His estate was just settled about a year and a half ago. All right. Why? Because one, he was in California where those estate taxes are very high. But two, he had more than $11.8 million of assets. So the federal government got involved. And while the IRS was saying, oh, his estate is valued like this, like they put an extraordinary amount on it, but the administrators on his estate, which was his mother, said, no, it's not valued at that much. It's only worth this much. So it took them all those years to properly value his estate to determine what that was going to end up looking like. What was that large purchase he bought? It was the Beatles catalog. So that's why there was such an issue with Michael Jackson's estate, because not only did they have to figure out what he had as far as his regular assets, but now they had to value the Beatles catalog that he had just purchased. So when you neglect to plan, you plan to neglect. He had that will in place. However, that was prior to that major purchase. And I don't know if some of you remember this, but all of his other assets were teeter-tottering on not being his anymore. Right? Neverland was one of them. Nipsey Hussle. He is my example of somebody who attempted to plan, but didn't quite hit the mark. When I say attempted to plan, he did not have a will in place, but he had several life insurance policies. Not a bad idea having a life insurance policy. However, where he missed the mark was the fact that he had named each of his children as the beneficiaries on a policy. Again, not a bad idea. However, all of his children were minors. Nobody wants a 3-year-old getting $2 million, right? And in his situation, all of his children did not have the same mother, right? And some of those mothers couldn't manage $2, much less $2 million. So again, the court had to get all involved. The court had to say, okay, this is the mother of this child. Yes, this mother is capable of managing those funds for that child until they reach the age of majority. Hopefully there'll still be some left for that child. This mother, no, the court found, no, you're not capable. And so they had to name an independent conservator to manage those funds for the children. So again, he tried, but he missed the mark. James Brown. I don't know if there's anyone on here from South Carolina, but James Brown, um, uh, he didn't plan. I'll just say that he did not plan. If you recall, they didn't even bury him for a couple of years, and they had him frozen somewhere because they couldn't agree on where to bury him. They couldn't agree on who was going to get his assets. They couldn't agree on anything. He had a woman that he had cohabitated with for years. They were never married. In South Carolina, much like Georgia and many other states now, don't recognize common law marriage. And so yeah, it became a battle between her and his family and who gets what and where and how and when. When you neglect to plan, you plan to neglect. Prince, his royal badness, right? Prince died without a will. And I don't know if you all remember this, but he went through all of the process of changing his name to the artist and then to that symbol so that the record company wouldn't get his proceeds. Right? He was a brilliant businessman, yet he died without a will. Another aside, personal Shannon, I still believe somebody wrote a will for him. It's probably somewhere in a closet in Paisley Park, and probably some attorney that has since died and nobody knew him other than Prince wrote it. But I digress. I'm back on here. Right? Prince died without a will. So when he died without a will, he was unmarried. He had no children. So now what happens? It goes to those intestacy laws. Unmarried, no children. Then it goes back up to parents. Both of his parents were deceased. Then it goes down the line. Siblings. So he had three. I can't remember if it's 3 or 4 siblings. I think it's 4. 4 siblings, one of whom recently passed away, and I'll tell you a little bit more about that. 2 of his siblings said, we don't want anything to do with this. We didn't want anything to do with him while he was living. He didn't want anything to do with us. So what they did was they sold their rights to his portion of their portion of his estate to the record company. What does that mean? Even after all that Prince went through, the record company still ended up with those assets. Right? And the sister who recently passed away, it was last week. She recently passed away. She was an artist herself, but the only reason anyone saw anything about her passing away was because she got a part of his estate. So now what happens with those, with that part? All right. When you neglect to plan, you plan to neglect. Bob Marley, he died in the 80s, and they're still battling over his estate. I'm just going to say that, and I'm done with him. All right, Larry King. I don't know if you all remember Larry King, but when he died of complications from COVID, he was one of those that had a couple of handwritten wills. Again, not a problem, but his complicated things because they contradicted one another, right? That was part of it. And 2, one of them didn't meet the criteria established for a will. So it was highly complicated. That is Sonny Bono. I don't know if you all recognize him, but he was half of the Sonny and Cher duo. When Sonny Bono passed away in a crazy ski accident, he was a United States senator. He and Cher had been divorced for years, and they had disbanded the Sonny and Cher dynasty. However, he was remarried. He had a teenage son. He did not have a will. So what happens with all of those royalties from the Sonny and Cher dynasty? Well, part of that issue is, what did the divorce decree say? Right? And another part of that issue is, what did the laws of intestacy say? Does it go to his son? Does it go to his wife? I think Cher would beg to differ on her part of those royalties, right? Again, when you neglect to plan, you plan to neglect. Paul Walker. He's my second example of people who planned and did a beautiful job of it. Right after he finished filming the first Fast and Furious, he put an estate plan in place. It included the power of attorney, the healthcare document, the will, and a trust. At the time, he had 2 young daughters. They were both under the age of 5, I believe, when he did this. When he passed away, they were, one of them was 18, 19, one was early 20s. He set them up for life financially via that trust. So he's my second example of planning properly. Then the last one, Martin Luther King. We all know he preached, Dr. King preached about knowing he was going to die, yet he did not have a will. All right. Dr. King's Bible should be in the home of one of his children. Instead, it's at the Smithsonian. Why? Because his family bickered and squabbled over everything. He didn't have a will. The state got involved. The federal government got involved. And now his Bible is at the Smithsonian instead of with the family. All right. When you neglect to plan, you plan to neglect. So again, option 1, use the government's rules. Option 2, use your rules. You get to say what happens. You get to minimize those costs. You get to leave instructions for your family. You get to make your documents facilitate your plan, right? Everyone on here has a different image in your head of what you want your plan to look like, right? So make your documents match that. And oh, by the way, as laws change and family dynamics change, and you know, yesterday I worked at this place, and now I work at this place, and I lost that life insurance, and faith, family, fitness, fun, and finances often collide with death, disability, divorce, disqualification. Revisit your plan and make sure that it still aligns with what you would want. And you also, using your own rules, get to protect your family, you get to protect your stuff, you get to outline everything that you want. So we talked about the 3 rules to or steps to success: knowing the rules, knowing your predators, knowing your options. So let's recap. Plans. You plan for finances and legal issues. The document that goes with that is the power of attorney. When you plan for health care, the document that goes with that is the health care record. Some people call that part of that a health living will. Some people call it an advance directive. When you plan for all of your stuff and the legacy and what happens with that, the 2 documents associated with that, one of which is for everyone, the other is only for some people, is the last will and testament and a trust. All right. How do you create your rules? You put them in your voice in a way that actually works. You create the plan, you create the rules, you integrate those rules with your life and your stuff, and then you maintain those rules. I put this red wagon on here because there's some people that remember a time where we actually put stuff in a little red wagon and we went outside and played, right? If it wasn't in that wagon, it didn't get played with. Not that day anyway. Somebody might have gotten told about forgetting it, but it didn't get played with that day. So your red wagon, your estate plan is your opportunity to put everything in that wagon. So that again, if you become incapacitated, somebody knows, oh, this is in the wagon. This is what we use. Upon your passing, everyone knows this is what he or she wanted. This is how we're going to do this. And people can grieve without having to worry about the business aspect of your death, right? I cannot say it enough. If you neglect to plan, you're going to neglect the people that you leave behind. All right. Without creating the plan, integrating them, and maintaining them, it's not going to work. And it's not going to work if it's not in a legally sound document, right? All attorneys are not created equal. If somebody that's not an attorney tells you they can put your estate plan in place, they are practicing law illegally. It's called the unauthorized practice of law, right? You would never go to a pediatrician for your care as an adult. So don't go to an ordinary everyday attorney that does not practice estate planning primarily, because they don't know how all these documents talk to each other. They don't know how if you put one piece of the puzzle in the wrong place, it messes up the whole puzzle, right? That came to me during COVID when I was putting together a puzzle, and I got to the end and there was one piece missing. And it wasn't even in the very middle of the puzzle, but it was one piece missing. I could not unsee that piece missing after that. It wasn't complete. So make sure you don't let Google be your guide. Get with somebody who handles this all of the time. Here's my information. Feel free to capture my information. Everyone on here, by the way, is entitled to a complimentary consultation with me, even if you are not in Georgia. I know people all over nationwide, a couple of international as well. But let's continue the conversation. So many times we don't know what we don't know. And because of that, we make horrible mistakes and we leave our loved ones in a predicament that they cannot untangle. So again, my name is Shannon Wilson. I'm the founding attorney of Legacy Legal. And I think I'm turning it back over and we're going to do some more things and then have a Q&A.
Yes. Thank you, Shannon, so much. This was
Thank you.
great information.
Thank you.
Excellent information. I'm quite sure a lot of people will be reaching out to you. I will be one of them. And also, this is recorded, so we will have it on our subscribe to our page. It's going to be on We News page far as YouTube. So if you missed the information, you'll be able to go back and listen to the information again. So now it's time to give away those three gifts, which Janet Benford will be raffling off the names or selecting the names, as she will call them out about now. Janice, you ready?
Yes, I am ready. Good evening. What a wonderful presentation. It was awesome. I really enjoyed it, and I'm really glad that it's recorded as well. So we do have um, uh, three Adobe planners. These are digital. It is compatible with an iPad or an Android tablet. And thank you to Tammy Lewis or Tamara Lewis for donating these items. So once I call your name, if you would send me a direct message with your email address and phone number, that would be great. The first winner is Carolyn Lagan. Carolyn Lagan. Yes, please DM me with your email address and phone number. Congratulations. The second winner of the Adobe Planner Digital is Deborah Dixon. Deborah Dixon, please send me your email address and your phone number via direct message. And the final winner is Dr. Valerie Davis. Dr. Valerie Davis. So please send that information to me and we will make certain to get you your prize. Congratulations to all of the winners. I'll turn it back over to you, Deborah.
Thank you, Janet, so much. Congratulations to Carolyn Lagan. She's one of our We New members. So congratulations, Carolyn. And congratulations to Deborah Dixon and Dr. Valerie Davis. Thank you so much for joining tonight. So now it's time for the Q&A questions. If you have any questions, please place them in the chat, and that's where we will direct the questions to Shannon. Any questions? I have one question coming to you, Shannon. Here's a question. Are there different types of trust?
Yes, there are different types of trusts. So the main types that most people are familiar with would be a revocable trust and an irrevocable trust. A revocable trust is the one that has the most flexibility. It allows you to still manage your assets as you do currently. Most of the time, people serve as their own trustee in a revocable trust. It also allows you to freely move and transition and sell things quite freely. An irrevocable trust, on the other hand, one, you cannot be your own trustee of an irrevocable trust because you're setting those assets aside for the benefit of named beneficiaries. The second part about an irrevocable trust is it is only for assets that you own outright. So for instance, if you have a home with a mortgage on it, it cannot go in an irrevocable trust. It has to go in a revocable, right? There's nothing that can go in a revocable that can't go in an irrevocable, but it does not work the other way around, right? An irrevocable trust also comes with what we call Medicaid protection. This is something that a lot of people like to hear about. So the Medicaid protection, I'm sure you all have heard about people who spend down and give away things so that they qualify for Medicaid. Medicaid is income-based. Medicare is age and ability-based. Medicaid is income-based. And so every state has their own version of Medicaid. Many states, the threshold is about $2,000. Right. So what that means is anyone that has more than $2,000 of assets does not qualify. So what many people do is they take those assets that they own outright, like that house that's been in the family for 2 generations, and they move that asset into the irrevocable trust. And then 6 years later, when they apply for Medicaid, it looks like they don't own that asset. Why? Because the trust gets its own EIN number. It's a standalone entity. And so that's how a lot of times people qualify for Medicaid, even though they have assets, because they've set those assets aside. They're saying, I don't even control them anymore. And They still do that 5-year look back, which is why I said 6 years later when you apply for Medicaid. So yes, there are different types of trusts. There's also things like life insurance trusts where it's funded completely with life insurance policies, or special needs trusts for individuals that have some special needs that entitles them to government benefits. There's a special needs trust. And some of these can be combined. Like you can have a special needs provisions within a revocable trust, or life insurance components within an irrevocable trust. All of those things, they combine. But the two main types are revocable and irrevocable.
Great. That's a lot of information. Okay, how do you answer? Let me see. How do you answer that you have to have $1 million to a trust? I'm not sure the question. How do you answer that you have to have $1 million to a trust? I guess the question is, do you have to have $1 million to a trust? I'm not sure of the
No, you
question.
don't. Let me see here. How do you answer?
Linda, you might, I'm not sure the question.
So no, you don't have to have $1 million to have a trust. Um, Trusts are for those 4 categories of people I mentioned. Everyday, ordinary individuals can have a trust. A lot of times, especially when I'm working with my veteran community. So being a veteran, I don't know if there's any on here, but it comes with all kinds of benefits, right? That they're entitled to, that their family is entitled to if they pass away from something that is service connected. And so often our veterans don't know that. And then they pass away and their families are left struggling, not knowing that they were entitled to those same benefits. So no, you don't have to have $1 million. You can have, my grandfather, I love to use this example. My grandfather has 3 granddaughters, had 3 granddaughters. He has since passed away. But he used to say, when I die, if I only have 3 pennies, I want each of my granddaughters to get a penny, right? So you can have 3 pennies and put them in a trust, and the state that you live in is not going to get those 3 pennies if that trust is properly drafted and protected, right? So for most people, having $200-300 is more valuable to them than that person that's got millions of dollars. Right? And so it's more valuable to them to protect it. So no, you don't have to be a millionaire to have a trust in place.
Okay. If you do not have dependents, do you need to have an estate plan with a trust?
If you don't have dependents, so having dependents is not the controlling factor, um, but those other factors go into it. So if you own property, whether you have dependents or not, you should probably have a trust in place. If you're a business owner, whether you have dependents or not, you should have a trust in place, especially if the nature of your business requires certain licensure. So, for instance, I can't just leave my law firm to anybody. It has to be somebody who is licensed to practice law, right? So, my business succession plan names somebody that is licensed to practice law, and it names a backup. So not having dependents is not the controlling factor. For people who have assets, right? If you don't have dependents and you don't have beneficiaries designated on those assets, you should probably have a trust in place, because now you can say who gets them, even if you don't have dependents, right? Sometimes our dependents are not who you think. Like, for instance, I've had clients that have custody of an adult sibling with some special needs. Well, legally, they might not be a dependent, but they depend on you. So we have to remember language in that. Sometimes heirs are not who we think, right? Birth and adoption, especially in our communities, we have so many play cousins, right? If you want to account for that play cousin, then you should have a trust, definitely a will, but you should also have a trust because they're not legally entitled to anything unless they were born of you, adopted by you, or that's it, born or adopted, right? Even marriage doesn't automatically entitle someone to uh, become a dependent. And in some states, a spouse is automatically entitled to what they call an elective share. But in states like Georgia, I think Georgia might be the only state where you can disinherit a spouse, or you can disinherit people. right? But how do you do that? You got to have the plan in place that outlines that and documents it.
Interesting. Is a trust the only way that you can leave your home to your children?
No, it's not. So the trust itself is the document that we use to do that, but the deed is what's the controlling document. And every state has their own versions of what those deeds look like. Some states have what we call a transfer on death deed. And that is where you have a will, and in that will, you say, upon my passing, this property goes to person X. And here, I'm attaching to that will the deed so that when I die, person X gets the deed. Many states don't have that, but some do. And so, in states that do have that, if that is the person's only asset and maybe they only have, you know, one beneficiary, then that would be sufficient. They wouldn't even need a trust. But for
Okay.
people who do fit into those categories that need a trust, that could benefit from a trust, then that is the preferred method, especially in communities of color where we lose land, right? One thing I know for sure, there is not going to be any more land on this here earth. So if you have land in your family, keep it and do what you need to do to keep it, protect it, and maintain it. So, no, a trust is not the only way to do that, but given other scenarios and circumstances, it's probably the best way to do it.
Okay. Here's a good question you spoke about earlier. Their question is, I own a timeshare with three other people. What are the steps to leave this to my children?
So, it depends on what the deed looks like. And most of the time with timeshares, you all don't own that as joint tenants with rights of survivorship, meaning when one person dies, the other two now share it. And when the second person dies, that last man standing thing, right? Most of the time in timeshares like that, you own it as joint tenants, which means each of you have a percentage. So if it's three people, you each own 1/3, right? So to redeed that, you can only deed, you can only transfer, you can only say what happens with your 1/3. So if that looked like putting your 1/3 in a trust, and then you say in your trust, this is what happens with my 1/3, you can do that. If it looks like having an agreement, a written agreement between the three of you that says, you know, I get to give my portion to my children, or if I die, you get my portion, whatever it looks like, you can do that. But again, the documents have to facilitate the plan, and the documents have to be legally sound. So the only way to do that is to know, one, what the current deed says and how it reads, and two, what the implications would be of that as you all pass away.
Okay, Shannon. Now this is going to be, I think three people may have this question. If someone meets with you, before they meet with you, what list of documents should be put together, or what do they need to bring to you to discuss their estate or trust
Great question.
planning?
That's a great question. So when I schedule a consultation, I provide a worksheet. It's a handout. It's like 3 pages. I don't require people to fill that out because during the consultation, I ask everything that I need to know and I jot it down. But that document outlines things like children and dates of birth and what real properties you own and what bank accounts you have and what retirement accounts you have and life insurance policies and, what are your general plans. I don't require it to be filled out, but it certainly does get people thinking about some of the things we cover in that consultation.
Okay. Can you use estate planning software and kits and have an attorney review and look at the documents, or do the attorney need to do the paperwork on your behalf to make it legit?
All right, so my answer to that question is a little bit biased, and there's only a handful of estate planning attorneys here in Georgia that look like I'm assuming most of the people on this call, and we all know each other, right? And so my answer to that is, please don't complete it in a kit that you buy from Office Depot and then bring it to me to review. Right? Why? Because I'm probably going to tell you that kit that you got from Office Depot, it's not going to cover everything. They're cookie cutter, and they don't allow you to take into consideration varieties, and everyone is a variety, right? It just doesn't allow for that. They're cookie cutter, they're boilerplate. If you go to another attorney and have it drafted and you come to me to review it, I'm going to say no. Just right off the bat, no. I do not make it a practice to review other attorneys' work because I assume that if they are licensed to practice law and they are putting a plan together for you, you paid them to put that plan together, then you should trust them. And I'm not going to second guess anyone unless we're in litigation. All right. So I just don't, I do not subscribe to the allowing Google to be your guide in estate planning. It's too important, and there's too many intricacies that can be overlooked. And like I said earlier, all attorneys are not created equal. So if somebody does criminal law and bankruptcy, and oh, by the way, I also do estate planning, run, because this part of the law has too many things that could be overlooked. And if it's somebody who doesn't know when you put this part in your trust and this part in your power of attorney and this part in your will, they all connect. And if you don't know how they connect and what needs to be in one versus the other, then it could end up being more costly for somebody to siphon through that. It's like a spider web, right? And that makes the probate process even more complicated than it should or has to be. When I started practicing this area of the law, somebody said, "Oh my gosh, I heard estate planning is like family law on steroids." And I didn't really fully grasp and believe that until I was full throttle in the middle of litigating a probate case. And it came back to me, oh my gosh, this is like family law on steroids. Why? Because we had the cousins and the sisters and the aunties and the uncles and the brothers and everybody arguing and bickering over what could have been prevented had somebody simply planned.
Okay. Last question. We're running out of time, but um, is it expensive to have a trust?
Good question. So if you sign up for a consultation with me, I make a recommendation for a plan, whether that's a trust or not. And I tell you at that time what that investment looks like. By the way, if you're a business owner, now that investment, we include the business succession planning, and now it's a tax write-off. So your business is paying for it, not you as an individual. Even if you choose to pay for it out of your individual pocket, you can do that too. But believe me, your invoice is going to say that we charge the business. I will also say this. In many cases, it's more expensive and more costly not to do it than it is to put it in place.
Exactly. Seem like you cost more when you're dead than you are alive. I mean, and then you think of your assets is you anyway. This is excellent. Thank you so much, Shannon. I mean, you brought us so much information, and I'm quite sure a lot of us will be reaching out to you. We have your information. If you can just place it again in the chat. But like we said earlier, please go to our YouTube page where you can see all the information where it's recorded. If you have any questions about tonight, you can go back and review it and look at it just in case you missed some information. Just subscribe to our YouTube page at Women Entrepreneur Network, and you will see the information there. Or go to www.bewenew.com, and you'll see our YouTube there, and you can click on that. Is that correct, Stephanie? And you can go to our YouTube page. But thank you so much again for joining us. We really appreciate it. Please continue to follow our website where we have a lot of different community service informative conversations that we all should be aware of. This is open for all of us. And remember, knowledge is power. So thank you again. Have a pleasant evening. Thank you to our sponsor, Tammy Lewis. Thank you again. We all appreciate the gifts. You guys have a beautiful weekend and see you soon.